Next matter we're hearing is Florida Power and Light versus Velez. Good morning, Council.
Good morning. Alvin Davis, Charles Schlumberger for Florida Power and Light. We're here on a petition for a writ of prohibition. I need to be clear at the start. We're not suggesting the PSC can award damages or that PSC can construe contracts. I thought we made that clear in our papers, but it should be absolutely clear. And we're not seeking to deprive the trial court of jurisdiction over those issues in this case.
The remedy you seek is an abatement, in essence.
Yes.
And you're suggesting that the trial courts without jurisdiction to reach questions of liability before the PSC makes a determination of whether there was compliance with their standards by FPL?
Yes.
So you said there's no prejudice to the respondent if the court were to abate. If we were to grant your petition and require the trial court to abate pending PSC's actions in that matter, yes?
Yes.
Would it be your position if, for example, the PSC makes some sort of a determination that FPL in fact complied with their regulations and standards, that the trial court would be bound by those findings? Is that your position? Is it your affirmative position that the trial court would not be bound?
Yes.
And that in fact it would be a question of fact for the jury ultimately, or the fact finder, to make that decision?
Yes.
If that's true,
Just
in other words, if the
4 pages of my argument.
I know. So if in fact that's true, in other words, if in fact the PSC's determinations, whatever they might be, on whether or not there was compliance with the standards, is not binding on anyone in the trial court below, then why would we abate to await such a determination?
I think that the answer to that is found in the decision in the Zenith case that we referred to. And the language of that case is the answer to your question. The rights and liabilities of the partners, together with the type and amount of recoverable damages, will be materially affected by the final result.
You agree that that case went off on a claim for a refund, for overcharges. That was the gravamen of the claim, though there was some general allegation of them seeking some other types of damages. I think the appellate court even said you didn't even plead those damages sufficiently.
Yes.
It went out on a refund, an overcharge claim. This is, I think both sides agree, not a refund or overcharge
It is not.
case. So I guess what I'm asking is this: how is this any different than, let's say, an airplane crash where there's a negligence claim, I won't say garden variety, it's an airplane crash, but let's say just a straightforward wrongful death action, and the NTSB comes in to investigate, and the defense moves to abate and says, hey, wait a second, there are all kinds of standards that we believe the plaintiff is alleged in its complaint were violated, NTSB regulations that were violated, and we want, Your Honor, to abate this action and not allow the plaintiff to proceed until the NTSB completes its investigation and determines whether or not the manufacturer or the airline itself complied with the NTSB regulations. How is this any different than that scenario, which I would imagine would not be abated under any circumstance? Why is it different here?
It's a curious point because the litigation that's going on now over the bridge is effectively abated while the NTSB...
But not on a jurisdictional issue.
No.
I'm not talking about the exercise of discretion. We're here on a petition for prohibition.
Yes.
So either the trial court has jurisdiction or it does not. And so I guess what I'm asking is, how can we reconcile what seems to me to be an analogous scenario to this? Your argument that it would make sense for the court to abate, that it could abate, it seems to me is beside the point. The question is whether it's required jurisdictionally to obey.
The difference between the Southern Bell case and the current case is that there was a rule enacted in 2007 dealing with these specific issues, dealing with vegetation removal, dealing with pole replacements, dealing with the entire panoply of regulation of all utilities in the state. And that rule specified that any customer, these are customers, complaining that the FPL in this case did not comply with its obligations under this the generic category of storm hardening. The rule says anyone that has a complaint that FPL did not comply with it, the PSC will address that complaint. And the essence of what we're presenting here is...
I'm sorry, before you get to that point, to what end? In other words, if the customer has a right to complain to the PSC that the storm hardening didn't occur, to what end would that customer complain? In other words, if the customer is right, what happens?
Customer is right, then the PSC can order FPL to correct whatever it has not been doing.
Right, so that's future. You're looking to
It is
future
future.
conduct required of FP&L.
What we're trying to do is to harmonize that rule that says the PSC will address it with the jurisdiction of the civil court to decide the damage case. And I don't believe you can just ignore the rule that says they will address it.
But they're two separate issues. I mean, one is for corrective behavior or corrective action for FPL, and the other one is for damages.
Agreed.
Which you agree that the PSC cannot award anyway.
Oh, yes.
So I'm missing the connection. Why should it even be abated for the purpose of the PSC, considering whether FPL should correct our procedures?
Because it's what will happen down the road if that doesn't occur.
I know, but I guess my real question is, what difference does it make? What difference does it make to have the PSC do its corrective work before the court continues with its matter on the class action?
Because if the PSC determines, and we've put in our papers all of the procedures that the PSC has gone through, all the hearings and all the reports, and the regular monitoring of what these companies are doing. If you go to the PSC, the PSA says these are the regulations that govern, because there are no regulations cited in the complaint. There's nothing cited in the complaint. There's not even a contract complaint. But if PSC says, yes, these are the requirements for tree vegetation every 3 years, or inspections.
So is the PSC's, let's say that it goes to the PSC first, it considers these issues and makes a determination. Is that determination something that can be offered as evidence in the class action case?
Yes, there will be.
For what purpose?
To establish that FPL did not violate any duty, that it did not violate.
Or that it did?
Did not. Either way, we're saying, however it comes out, it comes out. We're not saying it's only going to come out for FPL. But the importance of it is this. I mean, this is a purported class action, and they're representing, at this point, everyone in the state of Florida. Presumably, if they go to the PSC, as we're suggesting should be required, and the PSC says, this is the standard, we've monitored it, FPL has complied with it, then perhaps the plaintiffs are going to determine whether or not to proceed with one of these very expensive cases. I mean, the timing of our writ, our petition, is to essentially avoid the largest expense in a class action.
I think you make a great argument about judicial economy, to be honest with you. I think you make a very compelling argument in terms of the structure of how things should go. But this is not an issue that calls into question the exercise of our discretion, nor, frankly, does it raise an issue with regard to the trial court's abuse of discretion. This is a plain and simple black or white jurisdictional issue. Not should the court do what it did, but can the court do what it did? That, to me, is really the problem, as I see it, with regard to the arguments you're making, aside from issues of judicial economy.
That gets me to my fallback.
Okay.
We think the rule requires the court to exercise its discretion to go to the Public Service Commission as a first step, for the reasons we just discussed.
But, I mean, the exercising its discretion is different from compelling it to take a particular action.
Yeah, I regretted that statement as I said it. The court in the Southern Bell case, because this rule was not in place, said they're sending it back to ask the trial court if it chooses to exercise its discretion. We think the rule requires the trial court to send this to the PSC. But my backup position would be, if the court doesn't feel, this court doesn't feel it can require the trial court did not express anything on this. The trial court, after this thing had been briefed to within an inch of its life, just said no, and denied. I think that it would be, at the very least, this court should refer it back to the trial court with the direction that the court should consider exercising its discretion.
Well, that's an exercise, just saying no is an exercise of discretion, isn't it?
I'm sorry?
Just saying no, isn't that an exercise of the trial court's discretion? I mean, I would agree with you if the court said, I have no discretion to consider sending this to the PSC, and therefore I won't. I agree with you that if the trial court said that, then we'd say, trial court, you do have the discretion to decide whether to abate or send to the PSC or not. Those are different things again. You agree with that, right?
I do.
Let me ask you, something else aside from these things that are combined. Everybody seems to be referring to paragraph 7 of the electric infrastructure storm hardening. Am I correct, as being the basis that it should go back to the PSC?
That's where the rule is.
That's where the rule is. I seem to read this rule differently than everybody else. And help me to understand where I'm going wrong. Because I read this rule as a rule saying any dispute, in other words, I'm an FPL user, and I have a challenge to the storm hardening plan, to the standards or the strategy being used, then I go to the PSC to get that resolved. Isn't your allegation, your complaint slightly different? Which is, look, you were supposed to do this, you didn't do it, therefore we were damaged, and we get compensatory damages. Where am I know there's a fine line here, but tell me where my thinking is wrong or my interpretation is.
Well, my recollection of the rule I'm looking for is if there's any complaint about the plan or the implementation of the plan, and this would deal with the implementation of the plan. The plan requires tree removal. Did they not implement it properly? It requires inspection of the poles. Did they not implement it properly? I think you can't read that word out of the rule. The rule says that they will resolve any complaint about a plan or its projects implementing that plan. These are all projects implementing the plan. The plan is harden your system. The plan is trim every 3 years. The plan is test your poles.
I understand what you're saying. I understand what you're saying. I don't necessarily agree with you. I got you.
Well, I don't know how you would otherwise interpret implement, how they implemented the plan.
Well, I interpret it to any dispute or challenge. And I don't look at your lawsuit as a challenge. I look at your lawsuit as you were supposed to do something, you didn't do it, Therefore, we have compensatory damages, which can't be granted by the PSC. It's just one of the things that, as I was going through this, I looked at. We don't need to dwell on it. I just got hung up on it.
Well,
And many times I lose the forest for the trees, Mr. Davis.
I want you to leave the bench with a clear mind.
You should say with a clear conscience.
So you mentioned a few minutes ago that your argument is made more compelling by the fact that this is an expensive class action, or might be ultimately an expensive class action. So let me change the circumstances just slightly. Let's say this is an electrocution case, post-hurricane. Somebody steps into water with a down power line, and the claim is a wrongful death claim, a single plaintiff or survivor, alleging that FPL failed to comply with the storm hardening, and as a result of their failure to comply with the PSC regulations and the storm hardening requirements, the plaintiff's next of kin was electrocuted. Would your argument on jurisdiction be the same as your?
No, it would not. And it's,
So
and
tell me
it's-
why it's different.
Well, it's like the Ramos case that they cite, it's like the Traywick case that they cite. Those are one-off incidents where it's one plaintiff coming in and saying, you comply with this regulation about your wire. This case is about plaintiffs coming in and saying, your whole storm hardening effort was a failure for 2 decades. I don't know how they go back that far, but that's what they're saying. And the consequence of it is that if the court is then set to determine it without any reference to the Public Service Commission, then you've got the trial court setting the standards for tree removal, vegetation removal, pole inspection. You are making the trial court a mini Public Service Commission.
Well, it might be if they were seeking declaratory relief or injunctive relief, but it does not appear to me in the complaint that they're seeking either one of those.
What they are seeking is to determine that a duty was violated by FPL. In order for there to be a duty violated, you have to establish what is the duty. And the duty is, what was their duty for storm hardening, what was their duty for tree removal? And so the court is going to have to determine that in this case.
So now we're right back to the electrocution case, as you described as a one-off. The only difference is the nature and scope of the regulations that are claimed to have been violated, or the nature and scope of the regulations which purportedly created a duty. How is it different in kind? It may be different in degree, I agree with you, but how is that different in kind from the one-off electrocution case?
The difference is that it becomes a court establishing system-wide standards that would arguably apply to every other utility in the state as well.
Respectfully, I don't see it as that. I see it as a court determining whether the standards that were already established by contractual provisions or rules were followed by the utility in the court's assessment of whether or not there are damages and whether damages should be awarded. So the rules and the standards are already there. And it's not for the court to determine what those are. They're in black and white, right? Aren't they?
Not in the complaint, they're not. We don't know what standards they're talking about. So we're talking about going to the PSC to determine what the standards are. I agree that if you had a standard that said the pole should be inspected every 3 years and it wasn't inspected, and someone comes in and says it wasn't inspected, they can do that.
But if those things are not in the complaint, then that's not really a jurisdictional issue here, is it? It's not a matter of.
That doesn't make it a jurisdictional issue, no. The point is, the
And that's a matter you can take care of in the trial court.
I'm sorry?
That's a matter that you can take care of in the trial court.
There you are, yeah.
No?
No, I don't think so. But I'd like to get back, I want to get back to the rule, again, to clear your conscience. Because I think
Which rule are we looking at now?
we're looking at Rule 25, 6.0342.
Okay.
And I think with respect, your reading of the rule reads out the language about implementing the plan. That's what this is. These are implementing the plans. And it is any complaint by a customer, this is a complaint by a customer, as to how FPL implemented the storm hardening plan.
Or any projects implementing any of the above by customer? That's the language we're talking about?
Yes, no, complaint is by the customer.
Right. But see, I look at it as, or any projects implementing any of the above.
Yes.
This is what we're going to do. I go into citizens and say, wait a minute, this isn't gonna be good enough. I don't interpret this as saying, because you, FPL, did not do what you were supposed to do, and I have damages which are compensatory damages, that I don't see that falling under this section 7.
It deals with the plan, and it deals with implementing the plans. The plan is, for illustration, the plan is that they will do trimming of vegetation every 3 years. Implementation of the plan is they didn't trim vegetation within 3 years. The vegetation overgrew the wires. So I'm complaining not that you didn't have a plan for doing it, I'm complaining that you did not implement your plan. That's what implement means, and respectfully, you're reading that word out. There's a plan and there's implementation.
I got you. We've taken you way over. In conclusion, you can have a couple minutes.
Is it too late to reserve?
No, you can have a minute. We have a lot.
Okay, I think that it's a common sense proposal that we're making that is for the benefit of the court, for the benefit of the plaintiffs, and for the benefit of the field.
Thank you very much.
Good morning, Alfredo Armas on behalf of the plaintiff respondents. With me is Francesco Zacconi and Jose Florida. Very pleased to report. Judge Enos, in response to your queries from my friend, Mr. Davis, what would happen hypothetically if it does go before the PSC? This is the response. Florida statutes 36.07. This is what the PSC does. Whenever the commission, after public hearing, either upon its motion or upon complaint, shall find any service is inadequate or cannot be obtained, the commission shall determine, and by order, fix the fair and reasonable rates, rentals, charges, or classifications, and reasonable rules, regulations, measurements, practices, contracts, or service to be imposed, observed, furnished, or followed in the future, purely prospective, exactly what the Supreme Court said in Mogul 2. In response to your Honor's question, would this be advisory? Well, Mr. Davis says it will be purely advisory. The court can determine it, can use it, can.
Well, it can be evidence, it can be evidence of persuasion, right?
It could be
Or
evidence.
persuasive evidence.
But he says it in plain language, it would not be bound by those conclusions, referring to the court. It's an exercise, a silly exercise. Ramos addressed the same exact issue that Your Honor raised. In Ramos, the trial court, the lower court, entered a summary judgment. The farmer was accused of having 6 different meters and tampering with the meters, and he argued vehemently that no such thing had occurred. It went before the PSC. The PSC said, well, we think that you overused it, not by the $17,000 that FPL is saying, but by 1,000 something and change. The court, the lower court, then entered summary judgment based on that, as if it were binding on the court. This court reversed. This court reversed and said, absolutely not. That is nothing more than hearsay. That is a conclusion reached by the PSC. I'm not saying that there won't be some evidence that will come from the PSC. And of course, depositions will be taken to see if there has been compliance with these
So wait a minute, you're saying that whatever conclusion is reached by the PSC would be hearsay and therefore inadmissible as evidence in court?
I am certain that a lot, and remember the BDO side of the case?
I'm only asking you about a conclusion reached by the PSC.
I think the conclusion would absolutely be worthless. Absolutely worthless.
Meaning inadmissible?
Very well may be inadmissible based on hearsay. Some of the testimony from the commissioners will come in.
That's different. I'm talking about the
That is
conclusion.
different. Absolutely worthless. Look at Ramos versus Florida Power and Light. The PSC's limited authority to conduct administrative fact-finding regarding billing disputes and rates for electric power does not preclude a trial court's adjudication of a negligence claim for compensatory damages based on the totality of FPL's conduct regarding its customer. And the court reversed it. Reversed the summary judgment because it was based on nothing more. Now, my friend Mr. Davis struggles, and the reason he is struggling is because this is not a proper petition for writ of prohibition. This is not addressing the court's jurisdiction. All that if you read through the fine print, it says, send it back to the PSC. All that he is saying is, there is a failure of a condition precedent here. It's not jurisdictional. And that condition precedent is somehow you have to go back to this agency and exhaust a remedy even though we're not going to get a determination from them, you still have to engage in this exercise, which may be futile or not, going to your Honor's judicial resources and judicial economy thinking. So this is gonna be an exercise that's not going to give a lot of fruit. Depositions, discovery, traditional discovery processes of the commissioners is going to be much more fruitful in this case. But the.
Now, is it any different from the discovery that you will conduct in your case?
Absolutely not different at all, Judge. It is exactly what our trial courts are designed to do. That is where the specialty of the trial courts comes in, to ferret through the facts and ultimately determine liability, vel non, and damages that flow from that liability. But the Florida Supreme Court in Southern Bell versus Mobile America in 1974 said, address this exhaustion of administrative remedies and head on. It said, petitioner now takes the position that the circuit court does have jurisdiction, which is really what Mr. Davis is saying, over a claim sounding in tort and seeking money damages for past failures to comply with the standards set forth in Florida Statutes 364. But that the circuit court must obtain the benefit of PSE findings as to whether the applicable standards have been met. And the Florida Supreme Court addresses this issue head on. It says, the court should be free, the trial court, the lower court, though not required to refer such matters to the PSE for its findings in order to obtain the benefit of the state regulatory agencies' specialized expertise in the field.
So do you agree with his fallback position?
Absolutely not. There is no fallback position. This is within the discretion of the trial court.
That was, I think, what maybe his last fallback position was. That is that the trial court does have the discretion to obey the Senate.
There is no question. That is the pronouncement of the Florida Supreme Court in Southern Bell versus Mobile America. Mobile 2 says the court has the discretion. We take the view that while it may be desirable, depending upon the complexity of the issue, for the circuit court to utilize the expertise of the PSE regarding statutory compliance as to service, nevertheless, the circuit court is not required, and the emphasis is by Justice Kogan, not required to do so. Furthermore, we hold that such PSE findings, where sought, are not conclusive, but should be considered together with any other evidence before the court on the issue of liability and on the issue of damages if applicable to that issue.
So although it may be, and I'm gonna use the word appropriate, but I'm not sure that that's true, for
Proper.
FPL to file a petition for a writ of certiorari if the trial court refuses to exercise its discretion, prohibition is not the right remedy.
And it may very well be even an appealable issue, and Mr. Davis will come back and say the judge absolutely refused to look at the commissioner's testimony.
But you have to have some indication that the trial court refused to exercise its discretion, and if I'm a trial court judge and you present a motion and they say your motion is denied, that doesn't mean I didn't exercise my discretion.
Absolutely correct, Judge. Absolutely correct. Now, Judge,
Because I did that a lot, but.
I will say this. I believe verily that it is the plaintiff respondents that are going to use the PSC and the commissioner's testimony regarding compliance with FPL of these requirements of these states. Your Honor, Judge Suarez, hate to see you go, but Judge, you are reading it absolutely correctly. And let me tell you why you're reading it correctly. 2 reasons. First of all, each one of those references in that last paragraph is a defined term within the body of the rule. If you go back to those defined terms, you will see that those defined terms, implementation, the design, the deployment strategy, all of that is part of the contents of the plan that is required. Obviously, any member of the public can come in and complain regarding the contents of the plan, including the implementation strategy that is set forth by FPL. In addition, Judge, we have to read the rule in conjunction. The rule came after Bell South, Southern Bell Mobile 2. It cannot be an abrogation of a trial court's jurisdiction. It has to be read in conjunction with Article 5 of the Constitution, and it has to be read in conjunction with Florida Statutes 120.36, which says an agency may adopt only rules that implement or interpret the specific powers and duties granted by the enabling statute. Obviously, Mr. Davis's argument that somehow that language in the rule assigns, the PSC itself assigns to itself the jurisdiction to hear actions at law for money damages and for consequential damages. And respectfully, to my friend, Mr. Davis, he is wrong on that issue. I thank the board of the panel. Has any questions?
Thank you very much.
Thank you very much.
Mr. Davis?
I can only say that I would not like to be his enemy. I have this friend. I want 2 points. The Ramos case has no application here whatsoever. Ramos was a case of meter tampering, which is an endemic problem with FPL, where people put quarters in the meter, change the meters around. It has nothing to do with any kind of overall regulatory structure. And I've read what the proceeding was in the PSC, and I would agree that nobody should be bound by what took place there. There was a quick hearsay hearing over meter reading, meter tampering. Has no application here whatsoever.
But you agree that the court wouldn't be bound by the PSC's decision in this case either?
Bound by it?
Right.
No,
Do you believe
I
that
should, I think it should be, but the law is quite clear that it's not bound by it.
So in that sense, they're similar, but, so do you agree, or do you believe that the PSC's conclusion itself would be inadmissible in a trial in this case?
No, I do not, and I wanted to point out the language in Southern Bell, which is their favorite case, that the PSC is uniquely qualified to determine difficult technical questions regarding the adequacy, in this case it was telephone service, but it would be electrical service, as a technical staff whose functions include dealing with such difficult issues. The parties would of course be entitled to be heard, cross-examine witnesses before the PSC in an event of reference to trial court. So the procedure in the PSC would be fulsome. Its conclusion would be evidence if cases are clear about that. And in terms of the exercise of discretion, you're right, he could have been exercising his discretion out of the sight of the parties, but maybe he didn't. And I think in a case of this significance, with this prospect ahead of us of regulations all over the state, that the court should send it back.
You know, we have on a number of occasions sent cases back to the trial court because it has refused to exercise discretion. But those cases are pretty clear in the sense that the trial court has said, I don't believe that I have the right to do this, or I don't believe that I have discretion in this matter. So when the trial court makes a statement like that, then the signal to us is pretty clear. But when the trial court simply says denied or no, how do we make that assumption?
You don't assume it either way. We had an hour and a half.
Is this, let's go with that. Is this the type of case in which Florida courts have held that a trial court is required to make specific findings and on the record state the basis for its decision?
No. The motion to dismiss, but given the significance of this, the implications of it, it seems to me that a not unreasonable course would be to go back to the court, ask the court to exercise, determine whether it wants to exercise its discretion. The court says, no, I already did it, we're done. But the court may not have considered this. This is not a routine, run-of-the-mill issue that courts address every day. It's a case where, respectfully, although I don't think you can say this respectfully, I think the case got kicked down the road. Because the judge said at several points, we'll deal with this in some judgment. But I think he did not focus on the implications of that. And I would just ask the court to send it back and say, you may exercise your discretion to send it to the PSC. Consider that. Thank you.
Thank you very much. Thank you all.
Best of luck.
Thank you.
As far as your retirement.
Thank you.
I'm afraid that when you retire, this is when you retire. Thank you very much.
Thank you, Your Honor,
Thank you.
and I'm not far behind you.